You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Ms. Johnson, in cause number 25, DCCR 1826, you're charged with the second-degree felony offense of robbery, and that's from October 14th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet in that case some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in that case.
No objection.
It's admitted. Any evidence that Ms. Johnson's not competent?
No, Your Honor.
Right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of robbery. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Correction.
But we can just proceed on count 1 and each one of them to our pages.
Okay, thank you. Ms. Johnson, in cause number 24, DCCR 2151, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 6th of 2025 for the third-degree felony offense of forgery of a financial instrument. And that was a 6-year deferred probation. Is that correct?
Yes, ma'am.
And then in cause number 24, DCCR 2152, I also have a motion to revoke your unadjudicated probation. Shows you were placed on probation October 6th of 2025 for the state jail felony offense of abandoning or endangering a child, and that was a 5-year deferred probation. Is that also correct?
Yes, ma'am.
And then in cause number 24, DCCR 2153, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 6th of 2025 for the state jail felony offense of abandoning or endangering a child, and that was also a 5-year deferred probation. Is that also correct?
Yes, ma'am.
Each of these cases allege, and the state's elected to proceed on count 1 only. They all allege that you violated your probation in count 1 by committing the offense of robbery on October 14th of 2025. And is that true or not true?
True.
Did you enter your plea of true to count 1 in each of those cases freely and voluntarily?
Yes, ma'am.
And did you plead true because that's actually true?
Yes, ma'am.
In all 3 of those cases, I also have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed those, did you also go over them with Ms. Holmes?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow these agreements, that you also will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each of those cases.
No objection.
It's admitted in each case. All right, Ms. Johnson, in each of those cases, I'm going to find that you entered your pleas of true to count 1 freely and voluntarily. And clause number 24, DCCR 2151, find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of forgery of a financial instrument. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 2152, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of abandoning or endangering a child. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in cause number 24, DCCR 2153, find sufficient evidence to find you guilty, and at this time find you guilty of abandoning or endangering a child. Sentence you in accordance with that agreement to a term of 12 months in the state jail prison. You'll receive credit on that for any time that you've been in custody that the law gives you the right to receive. All 4 of these cases will run concurrently, which means together at the same time. I'm going to hand you in each of these cases. I did one more print. Are there 4 there already?
Yes, ma'am.
I'm going to hand you the trial court certifications in each of the cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, ma'am. You can go back with the bailiff. Thanks for being here. Have to take a break.
Good morning.
Good morning. Morning.
Still is a good morning, sir.
Well, that means he needs to be here. I'm just telling him what she knows. Okay, so I need her in here real quick, please. Apparently, Mr. Mills didn't sign a waiver. So,
Is that correct, Charlie, or am I wrong?
I did not see one in.
So just call and I'll be ready, so that it's gonna appear via calling. He's gonna be on the conference call.
I'm just not sure that that is that acceptable appearance, but, I think it would be better if they can Zoom and they need to go. I need to see his.
Because he needs to go with him if he did not. Okay, thanks.
Give them a minute and see if they can Zoom in. You've got Anthony Whitmire, Mr. Rojas. Oh, I don't have that paper yet. Let me, hold it just a minute and I'll call it.
Think you hold up on Whitmire?
Are you ready for, Whitmire? We're ready.
Okay, you can go ahead.
Thank you. I'll take it.
Beautiful papers. Wow.
And we're just going on the, possession case.
Yes, ma'am.
Notice how quickly this plea hearing moves. That isn't because the judge is rushing it, because both sides have already negotiated the agreement beforehand. Court is simply making sure the plea is voluntary lawful and that the defendant fully understands exactly what they're agreeing to before the sentence becomes official.
Good morning. Are you Anthony Whitmire?
Yes, ma'am. Good morning, Your Honor.
And Mr. Rojas, will your client with the formal reading of the indictment?
He will, Your Honor.
Mr. Whitmire, in cause number 25 DCCR 0057, you're charged with a second-degree felony offense of possession of a controlled substance from October 12th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Whitmire is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea. find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that for any time that you've been in custody that the law gives you the right to receive. I'm going to sign a dismissal as part of this plea agreement and clause number 25 DCCR 0056. I've handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Just thinking about yesterday, and this is a possession case, so I'm not sure how it applies. But because of the judgment entered against you, you could be ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas and read that document carefully. All right, you can go back with the bailiff.
Thank you.
See, and so am I going to have to start modifying? I think I'm safe just saying it, and
It's like
then
a citizenship thing, because you can't control whether it does or doesn't.
I know.
They readmitted.
But I mean, they've said specifically that possession is not one of them. In the Hambry case.
It really more says case by case, and I don't think it's such a blanket.
I would continue to give the.
I'm gonna say, yeah, as I was saying it, it made me think. Okay, make sure you send that dismissal over on Whitmire, please, and I'll get that signed. And then as soon as hopefully they're gonna zoom in on Norris.
Mr. Ernest is a plea also, Judge, if you have it.
Okay, Brendan Ernest. Brendan Ernest. Let's see, we're going on 3 out of the 4. 2.
Everything is very long.
Well, yeah, that makes-
Good morning. Are you Brendan Ernest? And Mr. Rojas, will your client waive the formal reading of the indictment in each case?
Here we are.
Now the stakes get even higher. Aggravated robbery is a first-degree felony. But instead of sentencing immediately, the judge orders a pre-sentence investigation that's often a sign the court wants a complete picture of the defendant's background before deciding whether probation, prison, or another outcome is truly appropriate.
Okay, Mr. Ernest, in cause number 26 DCCR 0429, you're charged with the first-degree felony offense of aggravated robbery, and that's from February 20th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? Then, let me take a second. And cause number 26 DCCR 0430. You're charged with a third-degree felony offense of obstruction or retaliation from February 12th of 2026. And how do you plead to that charge?
Good.
Again, are you pleading guilty freely and voluntarily? And because you did what they've charged you with? In cause number 26 DCCR 0908, you're charged with the second-degree felony offense of robbery, and that's from February 12th of 2020. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In all three of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal?
Yes.
So you can't change your mind if I follow the agreement. You understand?
Yes.
And it looks like the agreement that you've reached in all of these cases would be for 10-year deferred probations. There would be $500 fines in each case. There would be a dismissal in cause number 26 DCCR 0431, and you would be required to follow all the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Ernest is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence to find you guilty in each case, but I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing.
Yeah.
All right, you can go back with the bailiff. You've got Vicente Gloria, Mr. Rojas.
This hearing is very different from the earlier plea deals. Here, the defendant was previously found not guilty by reason of insanity, so today's focus isn't guilt or innocence. Instead, the court must decide whether it's still safe for the individual to remain in a psychiatric hospital or whether release is appropriate.
Good morning, ma'am. Are you Stacy Tyler? Yes, ma'am. And this is cause number 26 DCCR 0800. Ms. Tyler is charged with aggravated assault with a deadly weapon. Mr. Lewis, what is the announcement?
Judge, I've been talking with Ms. Tyler, and initially I was thinking it was just some mitigating information I was going to be getting to the state, but there is some that is material to the facts of the offense. And so I am asking for a little more time to do that, especially considering what the offer is from the state and her exposure.
Okay. And do you already have that, or you're waiting to get that from?
I am waiting on a little bit of it,
Okay.
so but it shouldn't take me too long.
Okay, so I'm just going to do a normal reset, Ms. Tyler, so that Mr. Lewis can get all of that information from you or whoever's getting that to him, get that information to Mr. Nichols, and then we'll get an announcement at the next court date, okay? You can go back with the bailiff. Janae Langerlow, Mr. Lewis?
And we're not going to need her out.
Hold on, okay.
That's a situation where initially she was set for competency, but had refused to see Dr. Capone.
Mhm.
I've gotten that worked out to where they can come over and see her at the jail. See her here.
Oh, I thought that was,
And
already can you get that?
we were trying to see if we can do it next week. I've been talking with Dr. Capone's
Okay.
office.
Okay,
We're trying to see if a date can be known where she can be brought over next week.
Sure.
I need to give Kelly on that.
all right, we'll just reset, a normal reset, and we'll get her brought over next week. We're not in trial next week, so it shouldn't be a problem.
Okay.
Mr. Parker, you've got Jacoby Murphy.
Jacoby Murphy.
We get the point.
Oh, God, you're right. That's why I didn't give you a breakfast out there. And 23rd? Yeah.
Good morning. Are you Jacoby Murphy? And Mr. Parker, will your client read the formal reading of the motion?
You will, Your Honor.
Mr. Murphy, in cause number 23, DCCR 0900, I have a motion to revoke your community supervision. Shows that you were placed on probation April 1st of 2024 for the offense of theft of property, a state jail felony. And that was, could you make sure, hold on, could you check that and make sure it's fine? Sorry. That was a 2-year term that was probated for 5 years. Is that correct?
Yes, ma'am.
And it alleges in this motion that you violated your probation. Count 1 alleges
Judge, I
that,
believe we would abandon that one. That one was not filed.
okay, just that one.
Just that one.
So we'll, count 2 alleges that you committed the offense of driving while license invalid, March 14th of 2026 in Bexar County, Texas. And is that true or not true?
True.
Count 3 alleges that you failed to report to the Jefferson County Probation Department, March 10th of 2026. Is that true or not true?
True.
Count 4 alleges that you failed to gain permission from Jefferson County, to leave the county and that you were in Bexar County on March 14th of 2026. And is that true or not true?
True.
Count 5 alleges that you failed to immediately report to the probation officer your arrest from March 14th of 2026. And is that true or not true?
True.
Judge, we can abandon the rest of them if you will.
All right. And so, Mr. Murphy, did you plead true to counts 2, 3, 4, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Murphy is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that for any time that you've been in custody that the law gives you the right to receive. I handed you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that. If you have any questions about the law that prevents you from having a firearm or how long it lasts, you can talk to Mr. Parker.
Yes,
All
ma'am.
right, good luck to you, sir. You can go back with the bailiff. I tried to make it short and then I mixed it up and made it longer and different.
But he was gonna ask you about his 20%.
Oh,
He's asking 5 times in like, you do that when you get there.
yep.
Okay, but I'm not telling how it works because I got my people. I said, no, you do it.
Yeah.
And you go ask her, come and get it. I said, she doesn't know you. It's not even happy.
Yeah, that's hot. I used to look at all those and do them myself. I would get emails every week, but then they have a way for you to just say, if they say they're doing well, then they can give it. And so I just did the blanket
Right.
thing to quit doing all that every week. Jose Amador.
About time you get a little read on a case like this. For a change. I think you're feeling sorry for having to deal with a couple of other prosecutors. This guy's been probation for 11 years on state jail, Judge.
How does that work?
He got deported to Mexico.
Oh. Yeah.
Happens.
Good morning. Are you Jose Amador?
Yeah.
And Mr. Parker, will your client waive the formal reading of the motion?
Yes, Your Honor.
Mr. Amador, in cause number 15-21599, I have a motion to revoke your community supervision. Shows that you were placed on probation March 27th of 2015 for the state jail felony offense of DWI with a child passenger. And that was a 2-year state jail term that was probated for 5 years. Is that correct?
Sure.
Is that right?
Yeah.
Okay. Do you understand?
Yeah.
Okay.
He does.
Count 1 alleges that you violated your probation. It alleges that you committed the offense of public intoxication April 9th of 2019 in Hidalgo County, Texas. And is that true or not true? Is it true? Okay. And then count 2 alleges that you are behind in your court assessed fees. Is that true or not true?
True.
And then count 3 alleges that you did not immediately notify your probation officer of your re-entry into the United States. And is that true or not true? Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? Did anybody force you to plead true?
No.
Did you?
Did you plead true because they actually true?
Oh, yes.
Okay, so all of those are actually true.
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these documents, did you go over them with Mr. Parker?
No.
Do you understand the documents that you signed?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Amador is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with this agreement to a term of 6 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It's in Spanish, and so you can read it so that you understand. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you have any questions about that, you can talk with Mr. Parker. All right, good luck to you, sir.
Okay.
And then Jonathan Hernandez, I'm signing dismissals in all of his cases. He's free to go back.
Judge,
That's true. Oh, it is? Okay. Are they already re-indicted?
Judge, he actually. On those 3 cases, he was technically still a juvenile when they occurred. So he now has a directive to apprehend holding him in the jail. He's not going to get out.
Gotcha.
Those cases just need to go through that process.
Okay. All right. I'm signing those now. Thank you. I know.
No, that's fine.
Yeah.
I'm just signing.
Who was that? Was that them?
No, yeah, but it's
It's just,
automated thing out.
oh,
That was on.
This bond hearing is about much more than money. The defense presents rehabilitation efforts, treatment records, employment, and even heartbreaking family circumstances. The judge's job is balancing compassion with community. SovCit reminder that bond decisions involve far more than simply setting a dollar amount. Listen carefully to the judge's warning. She's making it crystal clear that this isn't just another chancey, it's likely the last one. Strict bond conditions like alcohol monitoring treatment and a driving ban are designed to protect the public while giving the defendant one final opportunity to prove he can follow the rules.
The state will call this, Joseph.
Miss Joseph, come on up, ma'am. Good afternoon, ma'am. If you please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, ma'am. You can have a seat. You may proceed.
Thank you, Your Honor. Good afternoon, Ms. Joseph. How are you doing?
I'm all right. How are you?
Give the court for your full name, please.
Joanna Joseph.
And you work as a probation officer for Jefferson County.
Yes, sir.
And can you tell me how long you've been doing that?
It'll be 8 years, September 26th of this year.
And have you always monitored Desarian Adams?
Yes, sir.
Do you recognize him in the
Yes,
courtroom today? Is that him sitting right here?
Yes, sir.
And you're familiar with him and his case and what he's done on probation.
Yes, sir.
And when he initially was on probation, was he sent to a program known as ISF?
Yes, sir.
And what is the purpose of ISF? It's a multi-track program. Which track did he go?
Mr. Adams completed the cognitive treatment track. So it's to address thinking errors and cognitive, like to thinking errors, to get him or to get those in the mind of thinking about consequences of actions.
Because
And
18, 19, 20-year-old men don't have fully formed
Now we hear testimony from a probation officer, and this can be incredibly influential. Unlike attorneys, probation officers work closely with defendants over months or years. Their observations about attitude, compliance, and genuine progress often help the judge decide whether rehabilitation is still realistic.
brains do this. We know this from being parents and where we work. And the cognitive track is to help them with that decision making, understand there are consequences. And
yes,
try to think out before you act.
yes, sir.
Okay. And he was successful in all that. When did he complete ISF?
Oh,
If
some
let's say,
time ago.
if he started probation in September of 23, he would have immediately gone through ISF at that point. Is that right?
He probably discharged in 2024.
Okay.
Yeah.
And until his hearing in December of 2025, had he had any real problems on probation?
Mr. Adams has not given me any problems.
He reports
He reports as
that's
directed,
clean, right?
and his urine analysis are negative.
Does he have any problem with community service?
Yes, he has not satisfied the CSR condition.
But it's not a major violation.
No, it's not. He did perform some community service for a group that Jefferson County CSCD does not. We are not in contract with them, so that what he did does not count.
So he did community service, just not through really an authorized provider. Is that right? Okay. Part of probation is not to hang around people who are committing crimes or doing drugs or acting up. Is that correct?
Yes, sir.
And riding around in the car at night smoking marijuana would qualify as hanging around disreputable people. Is
It
that
does.
correct? Okay. He's on probation for deadly conduct. Do you recall the circumstances of of that case and what happened?
That I recall from the initial PSI that they were firing weapons at an apartment complex. Children and women, elderly, people not involved were around and could have been injured.
And he was in what actually turns out to be his mother's vehicle with 3 other individuals with guns, and they're shooting at another group in another car with guns.
Yes, sir.
And there's innocent people in the middle, and 2 people got shot in that exchange. Is that right?
Yes, sir.
And I know you made your recommendation that you think he could be successful and finish probation.
Yes, I do.
What specifically leads you to that conclusion?
Because from the onset of Mr. Adams' placement on probation, he has never justified the initial offense of deadly conduct. He never justified, he never minimized, he never rationalized. He readily admitted that he was wrong and had some difficulties in he felt guilty, and he felt bad about the fact that someone could have been murdered or killed. And so I had to work with him through that because it did not happen. That was not the reality. And it was a while to get him to move beyond that failure. But he's always presented as very respectful to me, he addressed me as Miss Joseph. He responds, yes, ma'am, and no, ma'am. And one thing that he does, that he looks me in my eye when he addresses me. And he has done everything that I've ever requested for probationers to do. He calls me when he's going to be late because he had to walk. And he would walk to probation, his visits in the rain and in cold weather, because he felt that was part of his penance.
This testimony highlights one of the toughest questions in criminal justice. Should a person's recent progress outweigh their past mistakes? The court has to balance accountability, rehabilitation, and public safety all at once. That's why these decisions are rarely simple and why every piece of testimony matters.
What can probation do if he's continued on probation? What can probation do to make him be successful or help him be successful?
I can help him. We all have free will.
We all know you can't make him be successful.
We have free will, but Mr. Adams is, in light of these offenses, Mr. Adams is driven. Mr. Adams has family support. Mr. Adams was in the process. He was working for a construction company, and he was in the process. We were going to ask Judge West to allow him to get the CDL, and it was a chance that it may have been out of Jefferson County because that CDL would have been free. And so I felt confident to ask Judge West to allow that for him. But that's what we were working on at that time, just to guide him into a career so that he could pay his fees and move on with his life.
Yeah. Thank you, Ms. Joseph. You know, I don't particularly agree with you on this case, but I certainly respect your opinion and your thoughts on it.
Same here.
Thank you, Ms. That's it.
Mr. Burbank?
Yes. Good afternoon, Ms. Joseph. How are you doing?
Okay.
Did you drug test Mr. Adams after this incident?
I sent him to the urinalysis technician, and she drug tested Mr. Adams.
And how many days after that? Was it about 2 days or 3 days after? If I told you it was about that?
This incident happened on Saturday. That Monday, he came in. I called him into the office expressly to drug test him.
Okay, and as a result of that drug test, did it return positive for anything?
It was negative.
Okay. And through your experience as a probation officer, how long does marijuana stay in your system?
If they are a frequent or chronic user, anywhere from 30 days up to a little over 2 months. If they are infrequent, about a week.
Okay. But you did it that Monday after he was arrested Saturday?
Yes.
Okay. Mr. Adams told me that he did approximately 300 of the 600 hours of community service. And are you testifying that some of those 300 hours did not qualify because they were not a qualified organization?
Yes, sir.
But you were made aware that he had done that much, correct?
Yes, sir.
And was he rectifying that in reference to the community service, seeing that he had done, in his eyes, half of it?
Well, that came out after his incarceration. He told me, his mom, I checked with my supervisor and we were not able to assist him.
Okay, it was just, they just didn't accept their community service hours, wherever he did it.
Yes,
Okay. But he told you about it, right?
he did.
And he talked to you at length, and I think it's in your report, about the construction and what he was working at and his goals. You seem like you took a lot of time with him, and I guess you saw some progress.
And I did. I thought, though, we had overcome the peer influence, negative peer influence. But yes, I did.
During my investigation and representation in this, did he ever tell you that he was at a place and he was asked to drive that car by the owner, Mr. Collins and Mr. LaSalle?
He did. After that office visit that Monday, no, I don't know if he called me or if he came back up, but he did tell me everything that happened after that office visit. That was impromptu because my report days are on Tuesdays and Thursdays, and I believe Mr. Adams will report on Tuesdays. And then subsequent to that office visit on Monday, he either came back or he called me, but he told me exactly what happened.
And that he was somewhere, they asked him because they didn't think they could drive, and they asked him to drive the car back to wherever they were going.
That's what he told me.
Did he ever waver from that story? Did he say, "Oh, I'm just telling you something"?
No, he hasn't.
And did he ever say that he knew that there was any firearms in the back?
No, that was, I think, the most adamant he was.
Okay. Or the marijuana?
Yeah, he denied that too.
He denied
but the urinalysis sufficed for me.
Right. There was nothing on the test that indicated that he was smoking.
Right. Correct.
Okay. He wanted to get his Twix card and his CDL so that he could move on with his career, correct?
Correct.
And what programs are there to help him
With what?
to get his CDL? And you talked about something that you reached out to the judge to ask permission. What programs are there through probation?
He found Mr. Adams found one, I believe that was in Harris County. But there was a program offered through Lamar, LIT, if I'm not mistaken, LIT, or it may have been the Lamar Port Arthur. And then there are subsequent to that, I have since found out that Texas Workforce has a program and the like. So he
was the one that was trying to go out and get a better job and then coming to you to tell you.
Yes, that, and it was twofold. He wanted to get a better job to pay his fees, and then he was concerned about his criminal record. I think he's on probation for 10 years, and so he felt that it would be hard for him to obtain gainful employment. So he felt like the CDL would be a better way to go, where he would be able to establish gainful employment and maintain it. And the construction would be a trade that he would have.
And you did say something about having family support. Did you, Ms. Joseph, did you ever reach out to his family, or did you have, or?
His mom reaches out to me. So I don't really have to call Ms. Parks. She calls me. So
Provide you with information?
well, yes. She's the child's mother, and Mr. Adams' mother, and then I'm the probation officer, and respectfully, we try to guide Mr. Adams without interfering in each other's lanes, so to speak.
And based on everything, and as you weren't excluded from here, but you sat here and listened to everything firsthand, in reference to the officer and the videos and stuff like that, do you still stand by your recommendation and your updated PSI report?
I do.
Thank you, ma'am. Good to see you again. Thanks, Liz.
Same restaurant.
If y'all don't mind, I have a couple questions. So, I'm just looking back at the administrative hearing to remind myself of some things, and in that it shows that he was on the high medium caseload where it was zero tolerance. Had he been on high medium the entire time, or had he been placed on high medium at some time throughout that probation?
High medium residence caseload was initial condition of his probation.
And he was still on that at this time.
Yes, ma'am.
And then there was something else. So the way this reads, that he reported on that December 9th. So December 7th was the offense date for the flee and the unlawful carrying. And then on December 9th, he reported where he was required to submit to a UA. They were negative. And it specifically says in this that during that office visit, he denied any interaction with law enforcement. Is that correct?
Yes,
Okay, so he did not immediately tell you about the arrest
right.
like he was
Denied.
supposed to. He denied it. Okay. Mr. Nichols, Mr. Burbank, anything, other questions?
No,
Your Honor.
Thank you, ma'am. You can step down. Mr. Nichols, do you have any other witnesses?
No, say yes.
All right, Mr. Burbank, any witnesses?
Call Mr. Adams, sir.
Sure. Mr. Adams, best you can before you sit down, raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Have a seat. Go ahead.
Police court.
Yes, sir.
For the record, could you state your name, please?
Zarian Adams.
You just lift that up just a little bit. Lift it up, yeah, so you don't have to bend down. The truth speaking to it.
You shouldn't
You-
have to hold it. You can let go.
You
It's good.
realize that today, judge has to decide what to do with you because of these violations.
Yes, sir.
You realize that you were looking at due to 10 years
Yes, sir.
in penitentiary. You ever been to the penitentiary before?
No, sir.
Have you been in troubles besides this?
No, sir.
Those were your first in trouble that you were placed on probation for in 2023?
Yes, sir.
As you look out here, do you have family support?
Yes, sir.
Do you have friends?
Yes, sir.
And what do you have to say to them because you're in handcuffs in orange with 1 foot in a bus going to TDC?
Yeah, I apologize to them
Well, what do you mean? Why would you apologize? It was your actions.
because I know I can do better.
Were those your guns?
No, sir.
Did you ever place your hand on any of those guns or hold them or carry them at all?
No, sir.
And you didn't, by your test, did you never, I guess you never smoked marijuana.
No, sir.
Were you asked that night to take those two people home, or specifically Mr. Collins home?
Yes, sir.
Is Mr. Collins here? Or LaSalle? Did you realize that both of those individuals came?
You can hear the frustration in Mr. Norris's voice. He believes he's made progress and wants another opportunity, but the judge isn't relying only on what she hears in court. She must weigh psychiatric evaluations, treatment records, and public safety in hearings like this. Medical recommendations often carry tremendous weight.
To my office to sign an affidavit here that I can't use, saying that was their guns,
Yes, sir.
but I can't present them. You realize that you're on your own.
Yes, sir.
How does that make you feel in reference to the friends that you tried to help out? Because they couldn't drive home that night and they're not here to help you out.
I have to put myself first.
They're putting themselves first, aren't they?
Yes, sir.
They're not your friends if they're not coming here to tell the truth, are they?
Yes, sir.
Okay. Probation officer is there. And she said some good things about you, but said that you had some problems and you had to, kind of have some work done. One of the things that you heard the judge say is that on the day after this, or a couple of days after it, you never made mention of the arrest. Can you explain that a little bit? Because she had a question on it. That's the judge.
Yes, I was kind of nervous and I was waiting until the charges were dropped to tell them.
You thought they were going to be dropped.
Yes, sir.
No, they weren't dropped, were they?
No, sir.
Because you're sitting there.
Yes, sir.
So, what should she do to you? I mean, let's put this on the table. Wouldn't it be better just to maybe do some time and be done with it instead of being on probation? Get 2 convictions on your record?
No, sir.
Why?
Because I don't want to be a felon for one.
Right? Well, if you didn't want to be a felon, then on December 6th, what were you doing then? Why did you make those decisions?
Trying to help a friend, but obviously they're not friends.
You were cooperative. You answered the police officer with everything he asked you. You didn't run or resist. So if the court was to consider giving you a second chance, what are you going to do? I mean, tell me what's out there. You got some letters from some people with jobs, but tell me, what are you going to do? In your own words. She wants to know.
I'll finish getting my CDL, go to school, and start driving.
Why didn't you do it before December 6th of 25?
But actually, my classes started on January 20th.
So you were accepted.
Yes, sir.
You were accepted to go to get your CDL
Yes, sir.
free of charge.
Yes, sir.
Are you asking this court to consider keeping you back on probation?
Yes, sir.
Hey, y'all stop talking.
You sure that's what you want?
Yes, sir.
When you get out, where are you going to live?
With my mom.
Is that where you were living before?
Yes, sir.
Does anybody else live with her?
No, sir.
Did you have a GPS on you?
Yes, sir. When I first was released.
Okay, and was it taken off?
Yes, sir. I had paid it.
But you paid. Did they take it off?
Yes,
I mean, were you told you could take it off?
yes, sir.
Was that pending before you got on probation?
Was it pending?
Yeah, before you pled guilty and were placed on probation. Is that when you had the GPS on you?
Oh, no. That was after I
After
got
that?
released from myself.
Okay, and then they told you after that you didn't have to wear it anymore?
Yeah, once I paid it off.
Are you asking to allow you to show the court that you're really a good person?
Yes, sir.
While you're in jail, how long have you been incarcerated?
About 6 months.
And write-ups?
No write-ups.
No write-ups?
None.
So you complied with everything they were doing in jail?
Yes, sir.
Pass the witness, Judge.
Thank you, Mr. Burbank. Mr. Nichols?
Mr. Adams, the Buick you're driving, that belonged to Jordan Collins?
Yes, sir.
When did you start driving?
Right when we left the party.
Where was the party?
Lamar.
At Lamar?
Mhm.
How long had you been driving before you got pulled over?
Roughly like 10 minutes. Maybe like 2 minutes.
So you left the party 10 minutes before you got pulled over.
No, when we left the party, however long it took to get to wherever the officer got behind us from, that's how long I was driving.
About probably 15 or 20 minutes, get
Yeah.
from Bar into Beaumont to over by Lucas, right?
Yes, sir.
When y'all told the police y'all last smoked an hour before,
Mhm.
what were y'all doing an hour before? Was that at that party?
Yeah, that was about give or take. Yeah.
Okay.
But
And just tell me if I'm wrong, but you said we smoked an hour ago. Or did
Yeah.
you not say that on video?
it's about give or take. If they smoke,
Did you smoke weed that night?
No, I didn't smoke weed.
But you were with them and they did.
They was inside the party smoking.
But I
I
mean,
didn't smoke.
I'm honest, I'm not even trying to play a game or anything. On the video, when the officer asked when y'all last smoked,
Mhm.
I thought you said about an hour ago. Am I wrong?
I did.
It's okay if I'm wrong.
I did.
You did?
I did.
You said that. Okay, you see why makes me think you were smoking marijuana when you say that, right?
Uh-huh.
Okay. But you tested clean.
Yes, sir.
That's good. Well, who is Jordan Collins?
The owner of the vehicle. My
Yeah.
friend. What?
Your friend? Who is Lyndon LaSalle?
He's Jordan's friend.
What are they doing with these things?
Hmm?
What are they doing with these guns?
I mean, I really know. I can't speak for them.
Were the guns in the car when you got the car?
I wouldn't know. They was in the back seat.
What were you doing from the time the officer hit his lights to when you finally pulled over?
Still drop.
And you're telling the court, you're telling your mother and everybody here, you had no idea that police officer was behind you for 2 blocks.
I knew it once we got to like Lucas. That's why
He had his lights on, he hit the air horn, all that before. You're saying you didn't notice.
Not really.
What does that mean? Not either yes or no.
When I did notice him, I kept driving until we got to the destination.
Where were you taking Jordan? Where were you going to drop him off?
We were going to the house that we stopped at.
Whose house? That house that it's ended up in front of.
Huh?
And were you going to keep his car? How were you going to get home?
No, there were other people pulling up with us. I was going to catch a ride with one of them.
Who?
Javon Sarah.
What's the name?
Javon Sarah.
Sarant?
Sarah.
Sarai?
Mhm.
You spell that for him?
Sarah.
Okay. So no matter what, you shouldn't have been out at night.
Yes, sir.
You shouldn't have been at any party.
Yes, sir.
And you shouldn't be riding around with people that are doing drugs.
Yes, sir.
You agreed with me on all that, right?
Yes, sir.
Who is it that is helping you get your CDL?
I was going through LIT, but the workforce sent me to LIT.
So it's a Texas Workforce Program. Who's your employer? When were you last working?
When I worked for the construction company, AWP Construction.
AWP, what kind of construction is it?
Traffic. I
Like
was
working on roads?
traffic controller.
Okay. How long did you work there?
Maybe like 6 months.
Do you still have that job if you get out of jail?
No, sir. I was working on getting my CDL.
When did you stop working the construction job?
I would say maybe like September.
So from September till the time of your arrest, were you working?
No, I wasn't working.
Were you looking or just getting ready for your CDL?
Getting ready for my CDL.
Okay. I'll pass it to Jessica.
Just one question. Do you have your GED or did you graduate?
I graduated.
Where'd you graduate from?
Evolution Academy,
And what year was that?
2022.
Nothing further.
Single.
Thank you.
Anything else, Mr. Nichols?
And then you're on.
All right, you can step back down. Any other witnesses, Mr. Burbank?
Your Honor, we have people here for support, but they're here for support.
And I've read all the letters, but there's no other witnesses. Did you want any names called? Make sure that no one's here.
I think Bob looked.
Okay.
But they were the people that were on, Mr. Collins and Mr. LaSalle.
Yeah.
They did come to my office this week, Judge. They did sign paperwork, but then
I'll even give him, I'll let him make a point. Judge, I was prepared to inform the court, Mr. Collins has a previous arrest involving stolen firearm in this same car. Same Buick, same license plate. So, I feel like that's probably at least something exculpatory enough to mention.
Okay, thank you. Okay, so first, with regard to the allegations, if y'all want to, I mean, I've obviously heard the testimony. If y'all want to make brief argument with regard to the allegations, but obviously the bigger argument is going to be what I do. Either of you on the allegations?
No, I mean, you know my argument. I can stand on these, what's in the video. There's a clear several blocks delay before he pulls over. I think it's a knowing attempt to conceal the evidence that's in the back seat, gives his friends time to cover stuff up. Speaks for itself, I think, on that issue.
All right. Anything on that, Mr. Burbank?
Video is a video, Judge. And just as the court knows, different world, it's not right, but they do tend to seek if they're close to, and they were where they were going, that they don't stop. It's not right. It's a violation of the law. But I would disagree with the officer that he tried to speed or get away. He just didn't stop. He used his direction signal. There was an indication, if the court would remember, and it probably doesn't because I know you've slept since then, when we first got here, was talking about how they saw, the state alleged that they saw movement in the car, but that was refuted by this officer that there was blacked out windows and there was no sign they were trying to conceal anything in reference to the reason why they didn't stop. But the video's the video, Judge.
Can you play it back might have you skip around a little bit. I want to go back
Do you want the dash cam or body camera?
a little bit of both.
Okay.
I want to see the dash cam. That was just really quick, so let me look at that first.
Holiday season at 8:30. Celebrate with sparkling students vote for it.
Not every defendant accepts a plea bargain. Sometimes the defense believes the evidence can be challenged or hopes for a better offer before trial. Rejecting a plea is a gamble. You preserve your right to fight the case, but if convicted later, the punishment can be significantly harsher.
That's all. Shop now at HM.com or at HM store near you.
Hey, no, all three are from the front of the head.
Right. That's good. And then I want to see really just a small part of the first part of where they were asking some questions.
Y'all got any spirit?
Hey, I'm saying out there, boy. Hey, who's the stuff? Hey, look what we got in just a minute. Go hang out up there for me. Nah, they ain't no trouble. No. No, we just make sure everybody has to, we'll scoot over our way. Hey, you're not close. Yeah. Everybody in the rest of the day wants to be entertained. Y'all step up there. Back up. Thank you.
Mr. Nichols,
Yes, sir.
is there another, after he does that, does he go back over and talk to them again?
He does, and that's when Mr. Adams says, I don't know anything about those guns. Ask these guys.
And
They're not for me.
Okay, all right, that's fine, thank you.
And I'll tell you, Judge, Officer Ramirez wouldn't have known the answer to Mr. Burbank's question about ownership of jackets. Either Mr. LaSalle or Mr. Collins, after they are released, asked if they can get their jacket back.
Okay.
So I will tell the court that. I just know that's at the end of the list. It is.
Okay, so with regard to the allegations, I am going to find, so Mr. Adams previously pled true to 4, 6, and 8. Count 1, which is the allegation of fleeing a police officer, I'm going to find that true. Count 2 is the allegation of unlawful carrying a weapon. I'm going to find that true. Count 3, failing to avoid persons or places of disreputable or harmful character, find that true. With regard to community service, I'm not worried about that at this point. We'll discuss that if I need to. Count 7 really is the same as count 2, that he was in possession of firearm. So I'm going to find that true as well. Mr. Burbank, you may proceed with argument.
Your Honor, as the court is well aware of what's going on today and all the problems. This is a very serious.
Well, and let me say this first also. I feel fairly confident, not fairly, I feel very confident that Mr. Adams knew that there were guns in that car and what was going on, and that they were hiding those guns and probably telling him, don't stop, and they did that. I'm not saying that I think he put them there, had anything to do with them necessarily, other than he knew what was going on when he was bringing them from that party. That when they got pulled, when those lights came on, if he didn't know, then he knew at that point, is what my thought is. So if that helps with your argument,
Well,
or whatever, clarifies where I'm thinking.
well, no, and my point being, Judge, is I've talked to the courts before in reference to other clients if I was placed on, or you or I, or Mr. Nichols was placed on deferred probation, and I was looking at 10 years of TDC, I would be calling Miss Joseph every day saying, I'm getting up, I'm going outside because I don't want to take that white bus up to Huntsville. But with Mr. Adams, you can tell he has family and other support here. And that they've been here since I've been around, in reference to representing him. But there's also signs, Your Honor, in reference that there's something there that I believe is worth saving with Mr. Adams. And that is Miss Joseph being very candid, because I've been many a times in which I've seen reports that weren't the same way from Miss Joseph. She's been very candid, very truthful in all her reports. So I would recommendation. And even with all that being said, of the recommendation, and ask the court to take a look at it again, which I know you have in reference to the PSI report. Here's a person that on his own was trying to make a better man of himself. That he was trying to get his CDL or trying to get his TWIP card so that he could get out of the environment that he was in. The other sign of this, Judge, as the court is well aware, and I've had many clients, his actions in jail when he gets around the population there of all these great people that are in jail and the problems. And I think I may have a record of somebody with 17, 18 pages, 19 pages of violations and nothing. And he's been there for 6 months. We know that he wasn't smoking marijuana because she tested him and it's negative. I think there has to be some sanction or some punishment. I don't know if 6 months waiting to this hearing, if there would be weekends or back on monitor. I don't believe that drug patch, seeing in light that he did not test, or he has not had a drug dirty UA here. We know that he's done community service, but that's, and then you heard the reason why it wasn't counted. I would ask that you at least give him a chance and place him there under some tolerance. Either give him some weekends or something, and try to get back on the CDL. I think he still has a chance because without the violation or the conviction, I guess he was accepted on January 20th to start the class. What a great opportunity. He just made a bad choice with friends, and you and I would have stopped. And all the issues with people or young kids and guns, and he should never have been around him. But if you take the totality of the circumstances, Your Honor, and I realize what the court's position has been for a number of months now, but he has shown something that says he may succeed, and he has somebody and people here that should have stepped in before we're sitting here today. And I'd ask that you consider keeping him out under some restraints or something that says that one more shot, no conviction, so you can get your permits and your license. But if again, that's it.
Thank you, Mr. Burbank. Mr. Nichols?
Judge, I could sit here and make an argument either way, very strongly either way. I'm looking at an arsenal over here of, and as a very much on one side of Second Amendment issues, I will acknowledge those are military rounds, guns. That's it. AK-47s are made for shooting people. And at the same time, he's on probation for being involved in a shootout with over 50 rounds fired and 2 people got hit. But I also saw the same video you did and looking at the same stuff you are. I don't know how the court's going to make. There's not an easy decision for the court to make here. In most other respects, he's been a perfect probation. I'll concede that. He's riding around on a Saturday night after curfew with guns in the car with two other knuckleheads who, at least by their admission, they were smoking dope. And if they were just so messed up they needed him to drive, he shouldn't have been out in the first place. He's had people in his corner every step of the way. His original PSI, the detective involved, pointed out that he was cooperative and polite. And he thought probation was appropriate. His mother brought him into the police and essentially turned him in because she knew when that shootout happened that he shouldn't have been part of it. Miss Joseph is in his corner as strongly as she's ever been for anybody. And he's got everything going his way, but here we are. And so either he's a master manipulator or he made a real bad decision and got caught. I just can't ignore the arsenal that's in the back seat while they're driving around on Saturday night. And their destination is what Beaumont police characterize as a known problem house. He's just, I love throwing back on people when they say I'm hanging out with the wrong crowd, that they're the wrong crowd. I don't know that in this situation. And I don't think there's an easy answer.
Here's another important legal wrinkle stacked sentences. The judge explains that if someone is convicted in multiple cases after trial, those sentences don't always run together. They can be served one after another, dramatically increasing the total prison time. That's often one of the biggest risks of rejecting a negotiated plea.
I think there's got to be something. And if he's going to be continued on probation, it's almost redundant to say, because he was on zero tolerance, high medium caseload. I'm sure whatever the court does will be appropriate in this case. It's just, it could go so many different ways. And I don't want to be back here in 6 months with another shooting. I'll leave it up to the court. It's a tough spot. And I'll concede that.
Who's mom? Mr. Burbank mentioned having these people. You've had all these people. You've had the support. Mr. Nichols is right. This is one of the hardest ones I've had in a long time, because I do see very easily both sides of this. It's very, very hard to ignore what's sitting right over there, especially because of what you're on probation for. I'm talking because I don't know what I'm going to do. You don't deserve another chance. You shouldn't have been at the party in the first place. If you hadn't gone to a party after curfew, then we wouldn't be here. It's that simple. Regardless of whether you knew what was in the car, regardless of whether you were smoking or drinking at the party, if you hadn't gone and followed those rules, we wouldn't be here. I mean, you've been on since 2023. Which is rare for someone your age to have done as well as you've done. It really is. It's great. I mean, I wish I was here saying you've done great and you failed to report a few times, Here's what I'm thinking, Mr. Adams. I want to know from you, first of all, if I even consider, which obviously I'm considering everything right now, or otherwise I'd have already been done to give you some time, right? Miss Joseph comes in here all the time saying, don't give this one an opportunity. And you're very lucky, and you've obviously made an impression on her. Your family has. But here's the deal. If I give you an opportunity to remain on probation, it's going to be with 5 additional years on each of your cases. All right, you only have 5-year deferred. You're going to have a 10, which means you have all that time left to do. It's going to mean you're going back to ISF because obviously you need some more thinking corrections to make better decisions and to understand that there are consequences to your actions. Or I can revoke you, give you some time, and you'll be done. But you'll have the convictions. How bad do you not want to have felony convictions?
I don't want any felony convictions at all. I don't do anything to not have any.
All right. Here's what I'm going to do. Don't make me regret this. Because if you do, we're not going to be talking about some cap of anything or 2 or 3 years. Don't make me regret this. Okay? I see what they see, but we're not coming back in here on anything else, period. All right? Not even a missed appointment. All right? So I'm going to find again that you entered your pleas of true in each of your cases to counts 4, 6, and 8 freely and voluntarily. Find those true. Find 1, 2, 3, and 7 true in each of those cases. Find sufficient evidence in each of your cases to revoke your probation. Not going to do that today. I'm going to continue you on probation in each case. In cause number 23, DCCR 0492, I'm going to extend your probation by 5 years. In cause number 23, DCCR 0493, I'm going to extend your probation by 5 years. You're going to be ordered in each of those cases to enter and successfully complete the cognitive track of the ISF program. And when you get out, you will have a GPS monitoring device and it will not be taken off until I say so. Probation will have to come to me. You will be, obviously, I want you to get a job and I want you to have training, but that's going to be the only reasons that you're not going to be at home. Okay. You're going to be on house arrest. So you can't, there's no call and ask Mr. Burbank to ask me, can I go to my cousin's birthday party or anything like that? Prove to me for some amount of time that you're following all those rules, get that education that you want to get a job. We'll talk about the GPS, but I don't want to hear whining about not being able to go to some family event. All right. Because if you don't do all of that, then you're not going to go to family events for a really long time instead of just maybe a year or so. Does that make sense?
Yes.
So you'll go from here to ISF, you'll get out, you're going to be on that same high medium caseload. You should be off of that by now, but now you're going to be on it for however much longer. Zero tolerance means zero tolerance. Okay. I won't forget today, and it's not good when I remember things, right? So I see a lot of people and I don't remember a lot, but I'm going to remember this and I'm going to remember every one of these people that are here today to be there for you. Hope that they will continue to do that and that you take that help. Don't be stupid and walk out of the house and tell mom, I'm going to a party. Go to a party, you're going to go to prison. It's that simple.
Judge, I'd ask that we add Mr. Collins and Mr. LaSalle as no contact list.
Yes. So you will all be, so a few things also. I mean, you shouldn't be anywhere with anybody, but for the duration of your probation, you obviously will have an order in both of your cases that you'll have no contact whatsoever with Jordan Collins and Lyndon LaSalle. You will also, so that I don't have to come back in later, you're not going to be allowed to go to, what's the address? Where'd they end up that night? You know the address where y'all went that night? What street was that?
On Lufkin.
On Lufkin?
4890 Lufkin Avenue.
So you can't go to 4890 Lufkin Avenue. And you cannot be, so this condition that says you can't be around people or places of disreputable or harmful character is kind of general. So I'm going to make it a little more specific. You cannot be around anyone that is smoking marijuana, that have firearms, that have any of those things in their house. So if you go to somewhere and y'all are having a barbecue, maybe after you get off house arrest and they start doing some stuff, you better leave. I don't care if you're doing it or not. You can't be around it. Those are what I consider places of disreputable or harmful character. It's being around the other people that if it's true and you're saying I was at the wrong place, wrong time, I think these two kids completely took advantage of you that night. And I think they're cowards for not showing up today because I do think that those were their guns. I have no doubt, but doesn't matter. You're here. They're not. Does that, you know what I'm saying?
Yes.
Anything else with regard to conditions? Ms. Joseph, any other conditions that you can think of that would be important for me to impose today?
No, ma'am.
So the community service, you have, I mean, they tell you where you can get it done at the right place. You got nothing else to be doing other than going to school. You're going to need to work. So I want to know, I'll give you permission to work because I don't want mom paying for that GPS. That's your responsibility. You're grown now. I almost said the wrong thing. You know what I was about to say, right? So act like it. You want to be a grown man, act like a grown man. Okay. Don't have her taking care of you. You help take care of her for a change. All right. This was not an agreement. You have some rights to appeal. I'm going to hand you that in a minute. I can't imagine why you would. I really, really hope you take advantage of this because I don't want to be back in here. And if we are back in here, then I don't want to hear from anybody about he's a good boy and he